Hello everyone, it's Wayne Jones, the Course Coordinator for Australian Employment Law. This is the second part of our discussion regarding enterprise agreements, which is dealt with predominantly in week 5, and I'm taking up the discussion from your textbook, Stewart's Guide up to Employment Law, from around paragraph 8.27 in the textbook. Now, some comments about what goes into an agreement. You'll see from your reading that much like last week when we were looking at modern awards, the Fair Work system provides that there are certain mandatory terms which need to go into enterprise agreements. They're probably not going to be a surprise to you, bearing in mind the conversation we had around modern awards. So those terms are, there needs to be something in the agreement regarding duration and expiry date, so that makes sense. How long is this agreement going to be, and when is it notionally going to expire? And if you think that one through, of course, there needs to be a notional expiry date so that it's possible to make an application to either renew the agreement or to enter into a fresh agreement or to terminate the agreement. Dispute settlement. There has to be something in the enterprise agreement that sets out how disputes are to be settled. There needs to be flexibility. Now, I think you're going to find that that's a common thread that runs through the Fair Work legislation. Remembering back in weeks 1 and 2 when we talked about where the industrial relations system had been and how it was moving to a system which was much more flexible in nature. So you're going to see throughout provisions within the Act, you're going to see some reference to flexibility. If I take you back to the objects of the Act, which are contained in Section 3 of the Act, listen to this. It says the object of the Act is to provide a balanced framework for cooperative and productive workplace relations that promote national economic prosperity and social inclusion for all Australians by, and the very first provision is providing workplace relations laws that are fair to working Australians, are flexible for business, promote productivity and economic growth, etc. So it's not unusual that you'd see a provision that required flexibility and consultation. There needs to be an opportunity for consultation within the workplace about the bigger issues. So just in relation to the first one, the duration, have a look at section 186(5) of the Act. It makes it clear there needs to be a specified date, so commencement date, end date. It'll be not more than 4 years after the date for approval. You should note, we'll talk about this again I think, you should note that even having an end date that was discernible, that date doesn't automatically cause the agreement to cease acting. So it will continue to run on until it is the subject of an application to terminate or until it's otherwise terminated under the terms of the Act. Dispute settlement, not much new there. You would expect that it would call for some form of procedure that allows resolution by the Fair Work Commission. But note in section 186(6) that what's also allowed is a procedure that allows resolution by an independent body. So it can't be the union, it can't be an employer organisation, but some independent body could be called in to settle disputes about the agreement or about the application of the National Employment Standards. And there is a model which is worth having a look at in Schedule 6.1, so do have a look at that model version. Can be mediation only, not arbitration, and it can really cover all matters pertaining to the employment agreement. So the fact of having a mediation clause doesn't need to just mediate those issues which are the fundamental issues in the agreement. It can talk about how all disputes are settled. Have a look at the cases, particularly around those 2 points, which will appear in the textbook. At around about 8.29. Flexibility terms. Again, you've seen this previously. You saw this in the provisions which dealt with the creation of a modern award, that there had to be something in there about flexibility. In this case, look at section 202, a requirement to allow for individual flexibility arrangements. 203 tells you what such a term must contain. And of course, like it was with modern awards, there has to be an opportunity for those flexibility arrangements to be discontinued if they no longer suit the parties, particularly if they no longer suit the employee. The default, if there isn't such a flexibility term, is the model, which is in Schedule 2.2. Have a look at that one. Consultation, again, fits in with Section 3 of the Act, how the Act is to be administered by consultation between the parties. So Section 205 says that the employer and the parties themselves have to consult over major workplace changes that are likely to have a significant effect on them. This now includes changes to regular working hours, and it does call on the employee to be or allows the employee to be represented if they wish at those discussions. Note the comments regarding pay rates, particularly at section 206. We'll talk about pay in a later week, but for now, just be aware that no matter what the enterprise agreement says about pay rates, they can't fall below the minimum rate set by the relevant award or at the safety net level by the national minimum wage case. So whatever the national minimum wage order is for that year, or whatever the appropriate award rate is as set by the relevant modern award, even if there isn't an increase clause, they'll be increased automatically, so they don't fall below that level. Now, a couple of things that are a little trickier. Unlawful terms for a start. Section 186.4 says that the Fair Work Commission can't approve an agreement with unlawful terms in it, and that's defined in Section 194 of the Fair Work Act as meaning discriminatory terms or objectionable terms. And it also says any term that allows parties to opt out. Those sorts of terms are unlawful terms. And look at 172, section 172.1. There's certain non-permitted content within an enterprise agreement. Matters pertaining to the relationship between employer and employee, matters pertaining to the relationship between an employer and a union, deductions allowed from wages, and how the agreement operate. They're all fine. They're meant to be the basic provisions that appear in an enterprise agreement. So provided they meet those descriptions, the content is fine. And we'll talk about matters pertaining in a moment. But if you have anything outside of those descriptors, it's not fatal to the agreement, but terms that you put in that don't meet that description are of no effect. They don't invalidate the agreement, but if anybody tried to enforce them as a term of the agreement, they would not be enforceable. And note the comment too about section 409(1)(a), that protected action can only be taken over permitted items. So if I go back again, non-permitted content is anything that's outside of that description. So if it doesn't relate to the relationship between the employer and the employee, the relationship between the employer and the union, deductions, the machinery provisions for how the agreement will operate, it's going to be non-permitted content. And if there was to be a strike on the understanding, or a lockout on the understanding that it was all over content, which turned out to be non-permitted, the party could potentially be left open to a claim. You'll see reference to this quaint phrase, matters pertaining to. Starting point is probably the case which does get a mention in the textbook, and I think, yes, there's a link to it there, the remanufacturing grocers case. They were looking there at that case at the question of provisions in an agreement which dealt with superannuation. But anyway, forget the detail because a lot of that has now been superseded. But the issue was that matters pertaining was defined in there as a matter that must be connected with the relationship between an employer in the capacity as an employer and the employee in their capacity as an employee in a way which is direct and not merely consequential. So that direct relationship between employer and employee with their employer-employee hat on is what can be a matter pertaining. It'll be clearer when I give you some examples in a second, and I just need you to know this in a sort of superficial way. You don't need to know this in great detail, but you need to be aware that that is the only restriction at this stage on things that can go into an enterprise agreement, and there's often a bit of litigation over this, whether something should be allowed in or not. The whole point of the exercise, of course, just not to get away from it, is that agreements are meant to be fairly short in compass, so they're not meant to cover a whole lot of details. The Fair Work Commission is quite happy for lots of workplace relations issues to be simply dealt with by way of policy within the organisation. Don't necessarily want to see it all lumped into the enterprise agreement. So the cases that receive a mention in this area talk about this direct connection between employer and employee, and in that relationship of employer-employee, not things that are managerial that you'd think would ordinarily be the manager's prerogative. So have a think about that in a second. The commentary, and when we have a talk about the commentary, but so again, 172.1 provides a definition, and was those things that I just mentioned a moment ago. The commentary to the Act is probably worth a look if you can get hold of an annotated copy of Fair Work. But I'll tell you what it says anyway. The commentary to the Act says this: the substantive terms in the enterprise agreement must be about permitted matters. So they've got to be about that employer-employee relationship. But ancillary, incidental and machinery provisions are fine. So there may be a provision about something that everyone agrees is a substantive term, and it's okay to then put in other ancillary matters. So, for example, just off the top of my head, if one of the allowable matters, if I go back to it, was about deductions from wages, and the substantive clause said something like it's acceptable for the employer to deduct and pay union fees from weekly wages. And then there were additional provisions that went on to spell out how that was to happen, and how the employer was to work out who the union money was to be paid to and what bank accounts and all that sort of stuff. Things that you'd think of as ancillary, incidental, machinery provisions, that's fine. They don't have to be taken out and put into policies. The issue is that the substantive term which sits above it, that is, it's okay to deduct union fees, it's about a permitted matter. So working out this whole business of matters pertaining really requires you to have a look at the common law. The warning that's given again in the guide to the Act says just be aware of cases which are pre-Fair Work might still talk about not to allow clauses which, for example, deal with unions or deductions, because they're now allowed under the Act, as we saw a moment ago, under Section 172.1, clauses about the employer-union relationship, and that includes things like being able to take time off to go to union meetings, etc. When they were questionable in the past, they're no longer questionable because they get a mention in the Act. So with that in mind, these are some of the examples which I've drawn from the commentary, and a few of the cases which are mentioned in your textbook suggest that these are examples of matters which are okay. Terms relating to particular staffing levels, if they're tied to health and safety. So a provision might say that on a mine site, you have to have not less than X number of employees monitoring a particular machine. That's just a made-up example. Might talk about staffing levels, say, at places like nursing institutions and at, say, childcare institutions, where the staffing level is being mentioned because it really relates to the health and safety of the staff and visitors to the site. Conditions or requirements about employing casuals. Now, note the terminology here: conditions, requirements about employing them, labour hire or contractors, if the terms relate sufficiently to job security. And the example that's given in the commentary is not on, for example, labour hire or contractors can come onto the site and undertake work, but they're not allowed to do so on rates or on terms which undercut the enterprise agreement rates. You can see the outcome of not having that in is that you could end up with predominantly contractors and labour hire people and no employees. So that's something that relates to the employment relationship. Converting casuals to permanents, there can be a process that's set out. If you have a look in the version which I gave you from the university, you'll see that there is that reference to opportunities to convert from being a casual to a permanent after 12 months. And also a clause, strangely, I don't know why it appears in there, but I'll mention it to you in the commentary. It said that the courts have agreed with clauses which make it clear that the employer can't ask for an indemnity from the employee if the employee causes damage. Now, I don't know the background of that. I didn't go into the case, and that's one I'll leave for you. But it just gives you an indication that it's still fairly broad, the sorts of things that can be seen to be part of that employer-employee relationship. Things that have been held by the courts to not be matters pertaining directly to that relationship are having a clause in there that just has this broad and general prohibition against engaging labour hire employees or contractors. So having a clause in there that just says the employer can never hire contractors was probably not only a bit silly, but it's very much a managerial question. That's for management to decide. It's because it's so broad that you can't really see how it relates directly to the relationship between the parties. A general prohibition from employing casuals, same sort of reason. Donations to political parties and social responsibility clauses. And the example that's given in the commentary was a condition which said that the company would only deal with other companies that had signed up some sort of undertaking to say that they would reduce carbon emissions, something of that nature. That has really no place in the enterprise agreement. Okay, well look, just before I leave that, don't overthink those too much. Just be aware that there is a rule around matters pertaining. If you're interested in this particular area, you could work your way through those cases and see further examples. But overall, I think the message that you get both from the textbook and from the commentary to the Fair Work Act is that you just never know until on the day. You've got a broad idea from those examples that I've given you that it needs to be pretty close to the relationship between employer-employee, but it's anyone's guess on the day how the court will deal with the particular clause. And remember, it may even be approved by Fair Work, but it'll be challenged through the courts, and they can have another look at it and perhaps form a different view. So don't get overexcited about it. Just have a look at some of the examples and be aware that there is that restriction which is ultimately there to try and keep the agreements short. They can be varied, and you can see there's an application possible under 207 and 208, pretty much like that common award, though it's a bit of a rigmarole to go through it. Employers and employees can jointly apply, and the employers themselves may even request employees to think about and approve a variation during the life of the agreement. So bear in mind that sometimes these agreements can run past their end date, so I guess that's possible that that might be the first step that the employer would take towards entering into a new agreement, is to ask the employees to start thinking about a variation. But have a look at the process. It's set out in Section 210, and Section 211 tells you the terms under which the variation can be made by Fair Work. Generally needs to be approved by a majority of the affected employees. Incoming employees can vote on it. The variation that's proposed needs to be provided in writing and explained. So you're probably getting the feeling already that it's pretty much the same sort of process that applied for the original agreement. So, in fact, I think the Act talks at some point about you go through the same sort of process by which the original agreement was put up, proposed, voted on, and then approved. Still has to have that nominal expiry date, and it can't be extended by a variation, and still has to pass the Better Off Overall test. So the changes that you're looking at still have to pass that test. And interesting, the Fair Work Commission has a discretion to look at all of that and still refuse to approve the variation on serious public interest grounds, but there are no particular examples given. So it seems to me that it's just the sort of discretion that's logical that they would keep. The agreements can run on indefinitely after the notional end date. So you could have an agreement that was likely to expire sometime this year, and it might take a year or two for the parties to eventually get around to renegotiating a new agreement. Now, it's not mentioned in the text, but I can tell you that one of the drivers for parties getting together towards the end of the current agreement is that issue that I raised with you last time we talked about enterprise agreements, and that is they often spell out the wage increases that have been agreed between the parties for the last 4 years. So I can't think what the wage increase is in the university enterprise agreement, but of course the last of those wage increases would have been had and received by the employees at the time that the agreement was up for renegotiation. So they'd be anxious to get something in place now for their next round of wage increases. So nevertheless, could just continue to run on indefinitely after a notional end date. And any new agreement can't operate while the old one's still in place. Can make a joint application under Section 219 to terminate, so both the employer and the employees. But once you get past that once you get past that notional end date, under Section 225, any party may apply to terminate. So if you get past the notional date, it doesn't require an agreement between the parties, but the Fair Work Commission will just make sure that it is in the public interest to allow that termination. But yes, just coming back to that one again, so the difference between those two, before it runs out, everybody has to agree and make a joint application. After it runs out, anybody can apply. The issue that I think we talked about previously about the nature of the statutory regime and the common law regime around contracts gets a mention again in the text in relation to the issue of contraventions and disputes. And the point is made again, referring to the Toyota and Mamara case, that enterprise agreements are not a contract. Contraventions will breach Section 50 of the Act, and there's certain civil penalties which will apply, and we'll talk about what happens in another week, in a subsequent week. But disputes generally settled by going back to the Fair Work Commission or in accordance with the disputes clause. So as I mentioned earlier, you may have some other body nominated within the agreement, or sometimes they can be settled in the first instance by the meeting of a disputes resolution committee that has nominated people on it. But now the issue of coverage and application, not new. You thought about this when we talked about modern awards. Sounds pretty much the same. Section 53, agreements cover employees expressed to fall within their scope, and it includes employees who are hired after approval. So I think the university one refers, for example, to all of the employees of the university. So that doesn't mean just at the date, at or before the date the agreement is approved. It just simply wouldn't work. It means all the employees of the university who are employed during the course of the agreement. And I guess that's why, when you think about the last time I was talking about enterprise agreements, I guess that's why the wishes of casuals who come and go a bit, they need to be taken into account as well, because they'll have a reasonable expectation that they're likely to be employed again over the next 12 months, or certainly over the life of the agreement. So, includes employees who are hired after the approval by the Fair Work Commission. No opting out is allowed. Everyone is covered. Everyone's going to be covered. You can't say all of the plumbers except for Bill Smith. That can't happen. Section 183, we've talked about this before. The agreement will cover unions who opted in after the agreement was voted up and approved. But before it was approved, they'll contact the Fair Work Commission and say, we want to be part of this agreement. And Section 51 says there are no enforceable rights or obligations under the agreement unless it actually applies to the employee. So what does that mean? Well, it means that the agreement has to be in operation. There's only one agreement at a time, so it has to be the one which is in application with respect to that employee at the time. The earlier one will still apply over the later if it hasn't yet expired. Under 54.2, if the agreement ceased to operate after expiry, if it's been it will cease to operate after expiry if it's been replaced by a later agreement. And remember, we've talked about this before. Under Section 57, the enterprise agreement applies to the complete exclusion of the underlying modern award. So remember also that I mentioned that even if the award covered more things, if you like, than the enterprise agreement, it doesn't matter. The whole of the award is excluded. Now, this can be a bit tricky, but for our purposes, please don't stress too much about transfer of business. The whole issue around transmission of business is probably a little bit easier these days. It used to be, there is a bit that swings on whether or not a business has been transferred across. You give you silly examples. There have been cases where getting the transmission wrong has meant that people have sort of double dipped into entitlements for payments for termination, and it's because of the whole transmission issue's been badly handled. But for our purposes, all you need to know is that Part 2.8 of the Fair Work Act, Section 311, provides a pretty comprehensive and broad definition. So it's broader than it used to be, which sets out the preconditions for transfer of the terms and conditions of the enterprise agreement with the employee. So what you're looking at is whether, when an employee leaves this business and goes to another one, do they take the enterprise agreement with them? And the answer is in the definition itself. There's two parts to it. So you have to have somebody who's being transferred, so a transferring employee has now started work for a new employer. I think that within 3 months is prudent, because you can imagine situations where there might be even a relatively short period where, I don't know, perhaps a person is required to take some leave while the whole transmission of business is put into place. So it's clear that it can be any time within 3 months of having left an old employer. They're doing pretty much the same work as they did before. So, put it another way, the employee probably wouldn't notice that they were now working for somebody else. So they've started work for a new boss. It's all within 3 months of having left the old one, and the work they're doing is pretty much the same as they were doing before. And there has to be a second part to it, and there's some sort of connection between the old and the new employer. Because if you think about it, the definition is going to be triggered every time someone leaves their job. They'd be arguing that they were taking their employment terms with them, and that's not what this section's all about. So there has to be those things. You've moved from one job to another within 3 months, and you're still doing the same sort of work, and there is a connection between these two new and old employers, and the connection is then defined in the second part of the definition, and it's pretty clear. Transfer of assets, I would read for that, it's pretty much simply a sale of the business. The business has simply been sold from A to B, something like that. Or the old employer outsources the work that you're doing to the new employer. So you've been working for Boss A, and Boss A suddenly says, well, I've employed Boss B to do that work, and I'm trying to think of an example. Perhaps something like you're the stop-go man for a construction company, and the construction company decides that it'll get a contractor to come in and do that work for them, so they'll outsource the work to them, and you're pretty much doing the same work. They've moved you across to this new company because they've decided to outsource it. And then in reverse, the new employer ceases to outsource the work to the old employer. So the example I gave you before, you were an outsourced worker, and now you've been brought back into the fold. Or the final catch-all on the end is the relationship between these two employers is that they're an associated entity of the old employer. You can have a look at the Corps Act, but just in general terms, it simply means things like you're a subsidiary or a related company where the shares in your company are pretty much substantially owned by the company that's the related entity. So just imagine companies and subsidiaries, that sort of arrangement. So just to clarify that again, the first part was you've got somebody who's moved from an old employer to a new employer within 3 months, and they're still doing the same sort of work, and there's a relationship between them, and really the relationship is somewhere between either they're already related, so they're two companies which are related, there's a sale from A to B, straight out sale of a business, or there's some outsourcing or ceasing of outsourcing. So most often happens just when a business is sold. Also applies when part of the work is outsourced, but note that at least one employee has to move to this new employer. There has to be some movement of at least one of the employees across to the new employer. The effect is the enterprise agreement transfers with that employee to cover them at the new employer. And note also the commentary that it is open for any of the parties to go to Fair Work and have a conversation with them about why it might be more prudent for the enterprise agreement at the new employer's business to be the one which applies. But the bottom line rule is that if those two parts are met from section 311 in the Act, then there's been a transfer of business, and the enterprise agreement travels to the new business with the employee. Agreements and contracts rate a mention in the text. I think these can be a little bit underrated, so be aware of this. The agreement sets the minimum terms. An employment contract can't validly provide for conditions that are less favourable than an agreement. We have a look at the couple of case examples that are given, but it is lawful to agree to more favourable terms, because you'll often see that messy relationship where one mentions the other, and I think we did have a look at a case that involved the UTS in Sydney, the University of Technology in Sydney, one of their employees, to think about the relationship between contracts and these statutory instruments. But again, you're seeing here that the employment contract really can't drop down below what's provided in the agreement, and it is quite lawful, though, for it to improve on things. So far as unregistered agreements are concerned, look, not much in that, but just be aware of what we've said previously about them not being contracts. So you can't have a bit of paper that's been mainly negotiated between the union and the employer, and then the employer goes broke, and expect the new owner of the business to abide by that agreement which has not been registered, because bearing in mind we've said all along that these agreements aren't contractual in base, they're not based on contract. Instead, you need to go through the statutory process that's set out in the Act to make them enforceable. So they could be, and I think to some extent the author is stretching things a little bit here, but we'll go along with it. They say, well, look, it could be an enforceable memorandum of understanding, and they did put up a case where there was that outcome. I think it was Modelling the Qantas case. But for me, the problem I have with that personally is that a memorandum of understanding to me is usually a non-binding agreement that talks about what parties' intention is in the future and how they might, pursuant to the memorandum of understanding, later enter into a contract, but an MOU is not necessarily a contract. Anyway, take that for what it's worth. There is a suggestion that a deed could be most appropriate. So that's where you've got a limited amount of material that can go into an enterprise agreement, and that's fine. The parties have agreed on that and they've had that sanctioned. They'd like to have a side agreement with some other things in it, although no examples are given. The suggestion from the authors is, well, they might just sign a deed. A deed, by the way, in case you're not aware, contracts need to be supported by consideration. I need to give you money. I need to give you something of value to make the contract work. But a deed doesn't need to have that consideration. It doesn't need to be money changing hands. So they've suggested, well, a deed might work. Not much in this, as I said. Don't get too concerned about it. The agreement in any event can't be in conflict with the statutory regime, so you can get overexcited about putting together a side agreement, but if it's in conflict with the enterprise agreement, then it's going to be void anyway. All right, sorry that took a little longer than I had hoped. I've gone over the half-hour mark, but they're my comments on the second part of the chapter dealing with enterprise agreements. Remember, we're at an introductory level. You're having an overview of 12 different topics, so don't get bogged down in too much detail here, and just be aware of those broader issues that I've raised with you. We'll talk again next week when we'll have a discussion about dispute resolution and enforcing employment laws, where we go to do that. Thanks for listening.